Is your business protected against the threat of malicious litigation and frivolous lawsuits? Are you sinking company profits into marketing campaigns that do nothing to contribute to the growth of your business? Bottled Business Sense provides practical business perspectives that uniquely emphasize both legal and media marketing strategies to protect and ensure the longevity of your business. And whether you're trying to provide a startup business with some level of stability or an established business with foolproof asset and estate protection, or simply attempting to get a better return for your business marketing dollars, Bill Bernard and Rick Moscoso will expose potential pitfalls to ensure the security and growth of your business, free from unwanted expense and the threat of litigation. You'll learn how to implement marketing and protection tools equal to those used by today's most successful corporations. Let's join Bill and Rick for today's Bottled Business Sense show.
Hey, good morning, everyone. Today is Tuesday, and here we are at 10 a.m. here on the West Coast. Something a little bit different in this episode, and we'll talk about that here in a little bit. If you're watching from the East Coast, good afternoon, and from the Midwest, hope you're having a good lunch. But anyway, we are very excited today because we're going back to our grassroots. When we first started the Bottled Business Sense show, we were actually live. And we went to tape delay for several years to make it a little bit easier. We could stock up episodes. But now we are going back to coming to you live. So here's the cool thing. Bill's in our remote office. And as we talk about different episodes, as we do different shows, you can actually comment in the live stream, whether you're watching from Facebook or from YouTube. Go ahead and drop a comment below, just to say hi. Let us know where you're watching from. We have viewers from all over the U.S., and we'd love to hear where you're listening from. So with that, let's bring on Bill onto the live stream.
Yes, sir.
And welcome him to the episode. Hey, Bill.
Hey, Rick. How you doing? Hi, everybody. Well, here we are. Movie stars in the making, huh? We're trying this out again, mainly because, candidly, it's exciting to be live with other people and to be able to answer their questions if needed, and to continue to at the same time bring you free material as we have been throughout the course of the last several years, which is something we've always enjoyed doing. So here we are, Rick, and we're ready to rock and roll, huh?
Yeah, we are. All right. What are we going to talk about today, Bill?
Well, today's subject is an estate planning subject, and it's about the Secure Act. And I made some detailed notes on this act. It's relatively new, and it involves retirement accounts and 401k accounts and how that interacts with estate planning. And I think what everybody should know is that effective January 1st, 2020, this new federal law dramatically changes the landscape for estate planning with respect to those accounts. Here's what it's called. It's called the Setting Every Community Up for Retirement Enhancement Act, thus the Secure Act. That's a mouthful, right? I'm not really sold on the secure part of this claim, but it does provide some interesting aspects. And it really has to do with implementing new rules regarding the payout of retirement accounts to deceased participants' beneficiaries, who can participate in 401k plans now, and who can contribute at what age to a retirement account if you're not deceased, if you still have the account live and well. So let's go back and review a little bit. Under the prior law, most designated beneficiaries of an inherited retirement account were generally permitted to take required minimum distributions, RMDs, from the account over the life expectancy of the beneficiary. So easiest way to think about this is if we're going to use Rick and his wife as an example. His wife is the beneficiary of his IRA. She can take out distributions over the course of her lifetime at an amount that she deems fit. And when she takes that out, she pays taxes on it, of course. So that's the way it was generally set up. by allowing the beneficiary to stretch the withdrawals out over the course of his or her lifetime, this allows for taxes to be paid, as I said, on only that amount taken out, but it also allows the remaining amount that stays in the IRA to continue to gain income, right? Interest, and to build. In most states, the Secure Act now eliminates the ability to stretch these withdrawals from inherited retirement accounts. Inherited retirement accounts, meaning Rick's wife inherits his retirement account after he passes. It eliminates these stretch withdrawals and rather requires that the total amount of the IRA be distributed within 10 years of Rick's death. So there are some exceptions to this rule. There's always exceptions to legal rules, right? We all know that. So going forward then, the Secure Act will limit the potential use of the lifetime of stretch rules with some modifications. And one of those modifications is where you name a spouse as a beneficiary, in this case, where Rick's wife is named as a beneficiary. Under the Secure Act, a spouse named as an outright beneficiary to an IRA may stretch the required distributions over the spouse's lifetime, number one, and number two, may even roll it over into her own IRA if she chooses to do so. Similarly, and we're going to get into this a little bit more detail in a second, if the trust is left as the beneficiary of the IRA rather than Rick's wife, you can stretch the retirement withdrawals out over the course of time as long as the trust document, the contract, the trust contract that you devise, provides for that. So the trust document must be in conjunction with that IRA in order for it to be allowable to stretch these payments rather than go under the Secure Act and have the full distribution within 10 years. But remember, that requires the trust to be the beneficiary, not Rick's wife. So we've said for a long time now that when you put a trust together and you put your assets in the trust, you don't necessarily need to put IRAs, 401ks, that sort of stuff inside the trust, because they have their own little built-in beneficiaries, if you will. They're set up to have a direct beneficiary, but you can make a trust the beneficiary of those accounts, in which case that account then does go into the trust, is funded into the trust, and then, of course, distributions can be made accordingly. So that's this spousal distribution, and that's an exception to the new Secure Act. What happens if you name children as beneficiaries? Well, that gets a little bit tricky. The majority of designations naming children as beneficiaries of your retirement account will result in the accelerated 10-year payout of benefits pursuant to the Secure Act. However, adult children and trusts that are set up for adult children, while subject to the new 10-year payout rule, you do have a situation where minor children or trusts for specific minor children of the plan named as beneficiaries will cause the clock to begin to run when the minor children reach the age of majority. So Rick leaves his minor children as the beneficiary of his IRA. That IRA will pay out to those minor children, and those minor children will have to take the withdrawal within 10 years of Rick's death, typically, right? But in this case, the minor children will have the 10-year clock run where they have to take the full withdrawal from Rick's IRA when they reach their age of majority. So if the child is 5, his age of majority would be 18. So that's when the 10 years would begin to run in order to take out the full withdrawal of Rick's IRA that was left to those children or that child. If you leave the IRA to a grandchild, that does not apply. So the grandchild's 10 years would begin to run from whatever age that grandchild is when Rick passes. Let's go back to naming the trust as a beneficiary. What happens if you put your trust as the beneficiary of your IRA? Well, prior to the adoption of the Secure Act, people set up what was called a conduit trust. And they were often used in conjunction with the lifetime stretch rules for distributing retirement accounts to beneficiaries. A conduit trust, by the way, is one in which all required distributions from a specific retirement account received by a trust are distributed annually to the specific trust beneficiary, with income associated with the required distributions then being taxed to the beneficiary at his or her own individual tax rate. With the new 10-year payout rule under the Secure Act, conduit trusts could cause punitive income tax consequences because beneficiaries will now have to realize a significant amount of income over a shorter period of time, since all the plan benefits must be distributed outright to the beneficiaries within those 10 years. Plan participants, therefore, somebody like Rick, while he's still alive, may consider naming an accumulation trust as the beneficiary. Now, remember, when we're talking about conduit trusts and accumulation trusts, again, typically trusts don't always become the beneficiaries of IRAs. But if you're going to name a trust as the beneficiary of the IRA and cause that IRA to be put into the trust, you might want to consider an accumulation trust, which allows the required distributions that collect inside the trust to be distributed at the discretion of the trustee who is running the trust over the course of time. The retirement account would be required to distribute the trust in full over the 10-year payout rule under the Secure Act, but it would be distributed according to the wishes of the trustee. And so that would mean that certain amounts would be distributed over that 10-year period, allowing you to pay less taxes on an amount that you take out now, as opposed to an amount you may take out 6 months from now, right? So either way, you're going to establish this accumulation trust. You're going to allow, I don't know what happened there. That was a glitch. But anyway, you're going to allow for the trustee to establish, okay, here's what I'm going to give you. Here's what you're going to pay taxes on, because you're a trust beneficiary and the IRA has the trust as its beneficiary. I'm going to give you a certain amount. You're going to pay taxes on that certain amount, but you're still going to have to take it all at least within the 10 years after the death of Rick, who is the plan participant. What about Roth IRAs? Everybody knows a Roth IRAs, you have taxes already paid, right? So Roth individual retirement accounts are subject to the 10-year accelerated payout rule anyway. But again, those taxes have already been paid, and so the beneficiary doesn't have to worry about paying taxes on that amount, even though that amount has to be withdrawn within 10 years. So, plan participants may want to consider a Roth IRA conversion during their lifetime before they pass, because that saves their beneficiary having to pay taxes on any withdrawals that are taken out under the Secure Act within a 10-year period after their death, right? So these are things you want to discuss with your estate planner. A few things about calculating the 10-year plan, the 10-year term. The payout must be distributed in full by December 31st of the year that contains the 10th anniversary of the date of Rick's death, or the plan participant's death, right? So we have to remember that. There are some exceptions when somebody passes in 2019 that affect the 10-year payout rule, and that should be discussed with your estate planner, because that can get somewhat intricate. So I invite you to sit down with your estate planner and find out what happens for decedents who die in 2019. I'll just say, generally speaking, a disclaimer of retirement accounts to contingent beneficiaries should be considered to lock in the lifetime stretch payment for contingent beneficiaries. That is a process that you need to go through and discuss with your estate planner if you have someone who has left you an IRA and that person has died in 2019. Now, we've been discussing inherited IRAs, excuse me, and how they affect beneficiaries of a plan participant. But what are the benefits of the plan participant before his or her death? The Secure Act contains some substantial changes that impact estate planning. And one of them is this. It raises the age for requirement minimum distributions from age 70 and a half to age 72. So now you don't have to take a distribution of your IRA if you're still alive until age 72. Previously, you were required to start taking withdrawals from a traditional IRA by April 1st of the year after you turned 70 and a half. These withdrawals, again, as I said, were known as required minimum distributions, and the Secure Act then pushed this age to 72 while allowing IRA owners to defer paying taxes on those funds while they were continually growing. That was the hope and desire, right? What about age limit for IRA contributions? Again, while the plan participant is still alive, workers with an individual retirement account used to only be able to contribute up again until age 70 and a half, but now the age limit has been removed. Under the Secure Act, you can continue to contribute to your IRA at any age as long as you're still working. At any age, as long as, however, you're still employed or you're still working for yourself. In 2020, the contribution limit for an IRA was $6,000 or $7,000 if you're 50 or older. If you and your spouse are 71 or older in 2020 and are still working, you can contribute up to $7,000 to an IRA in each of your names, or $14,000 total. So what does this mean? A lot of dates here, a lot of figures being thrown around. This is why notes are good, why sitting down with your estate planner are good. To recap, in 2020, contribution limit for IRA is $6,000, $7,000 if you're 50 or older, okay? If you and your spouse are 71 or older in 2020 and you're still working, you can contribute up to $7,000 per IRA or $14,000 total. Not complicated. It's just that you got to sit down and write these things down and look at them and see them in front of you before you really understand them. Let's talk briefly about penalty-free withdrawals from your IRA under the Secure Act. Again, if you're still alive, you're a plan participant. Prior to the new law, if you took a withdrawal from your IRA or 401k before age 59 and a half, the amount would be subject to an income tax payment as well as a 10% penalty. Everybody is pretty much familiar with that, I think. However, the IRS does allow penalty-free early distributions for some type of retirement accounts, such as when you have an expensive medical emergency or where you need to purchase health insurance after a job loss. Also, the Secure Act adds an additional exception to this list, and this is important. You're now allowed a $5,000 withdrawal from your IRA or 401k after the birth or adoption of a child, and you won't have to pay a penalty for withdrawing these funds. You still pay taxes, but you won't have to pay a penalty, for withdrawing this $5,000 from your IRA now under the Secure Act if you're going to have the birth of a child or the adoption of a child. And finally, under this act, I wanted to add one last item about 401k plans and eligibility, which is important. The new law provides a way for more part-time workers to be eligible for 401k plans. In the past, part-time employees needed to work at least 1,000 hours during a 12-month period to be able to contribute to a 401k plan. Under the Secure Act, however, employees who log in at least 500 hours now in a 12-month period for 3 consecutive years, 500 hours in a 12-month period for 3 consecutive years, and finally who are 21 years of age or older, now can contribute to a 401k plan under the Secure Act who couldn't before. Before, you had to be at work at least 1,000 hours during a 12-month period. Now, 500 hours over a 12-month period for 3 years, and you have to be 21. Now you can contribute to our 401k plan. So as you can see, the Secure Act changes some of the things that occur for an inherited IRA, whether it be a traditional IRA or a Roth IRA. If you are left as a beneficiary to a decedent's IRA, or if a trust is left as a beneficiary to a decedent's IRA and you are a beneficiary of that trust, and of course, in that instance, that trust and that beneficiary relationship must coincide and that the trust terms must provide for that. And it also provides for some benefits for the plan participant before death, and for people who might want to take early withdrawals from their IRA or contribute to a 401k plan. So this act is even more intricate than what I've tried to provide here. Our object on this show, of course, is to provide some succinct background information, which will then allow you to go to your representative, your estate planner, and sit down and plan for your estate accordingly. But it's not something that's always brought to the attention of people. It is an estate planning tool, and I wanted to provide that to you on this show, so at least you'd be aware of it. So that's kind of it, Rick.
No, that's a lot of great information. Like you said, you mentioned this is very intricate information, and I think it is very important that you reach out and speak to your estate attorney. If you have questions, obviously you can bounce them off a Bill at any time, and a dialogue there to see how we can help. At the top of the show, you mentioned, and I don't know if you were this just part of the dialogue, but it was a play on the acronym of Secure Act, and you said something. I'm not quite sure if that is
well
secure.
Yeah, but it's our habit on this show not to get too political. But I'll just say this: if you have the slightest modicum of morality within you, there are certain things going on today that you probably wouldn't approve of. And this Secure Act was part of a plan, the way I see it, to benefit certain people over others. That's my personal view, while also indicating that there are certain benefits, technically speaking, that the act provides. How secure it makes you, though, shouldn't be confused with the fact that the acronym was chosen based on the name of the act. And the act is called the Setting Every Community Up for Retirement Enhancement Act. And so I think specifically the Secure Act is meant to say this will help you be more secure in your income that you have while you're alive, and also that your beneficiaries will have once you're deceased. But it needs to be specified, I think, that it has to be part of your estate planning tool, your overall estate planning tool, because this retirement account in and of itself, by itself, to me, doesn't set up your security in and of itself, by itself, unless you have some incredible wealth and you can rely on an IRA or IRAs that have an incredible amount of wealth in it. I prefer to think that there's more a community of middle income people who have IRAs as part of their overall estate plan, and to have an overall estate plan makes you more secure, not this act in and of itself. So suffice it to say that I'll leave it there and not get too overly dramatic about it, but that's what I meant. Okay. And we talked about, Rick, many times on this show that there are a lot of things that people typically don't put in their trust. And now, while you always could put things like IRAs and 401ks in your trust, it really depends on your specific goals. And this act specifically addresses some of those things and provides some opportunities and suggestions on how to do that, I will admit. Because remember, when you put your plans that have their kind of own little built-in beneficiaries, as I like to call it, into your trust, you're then saying, okay, the beneficiaries of your trust will benefit from that retirement plan, for example, as opposed to one or two specific beneficiaries that you might normally leave as beneficiaries when you don't put your retirement account in your trust. It's not to say you couldn't still do that, but typically these plans were put into trusts when you wanted the trust beneficiaries, of which there was more than one or two maybe, to share equally in that IRA, rather than trying to list a whole bunch of people as your direct beneficiaries within the IRA plan. That means you have to go through discussions with the IRA administrator. You have to make sure that they're provided necessary copies of the trust certification in order that they can understand and know that that the trust document provided for this, in conjunction with the retirement account or 401k plan that you have set up. So again, all of these things are just reminders why you need to sit down with your estate planner and find out what your goals are. And then when you find out what your goals are and you decide to do these certain things, you know what comes down the road, so your trustee can be provided the information necessary to run your trust once you're deceased. Remember, too, that your trustee has to be informed as to what's going on. You just don't create a trust and create a trustee after it takes place after your death. In other words, the successor trustee steps in after your death if you're the trustee while you're alive. You can also make a different trustee while you're alive. But whoever is going to take over while you're after your death needs to understand what this document involves. And that's a responsibility, big responsibility. And that's the subject of maybe another show, because too many trustees are left in the dark. And sometimes those attorneys who created the trust are deceased before the trustor who created the trust dies. And then you've got a trustee who's finagling around trying to figure out, okay, what do I do here? Yeah. So these are all important issues, Rick.
And that's another episode that we could talk
about.
Yeah,
that's a total another episode. But I want to say that I hope people can appreciate the intricacy of some of the topics that we discuss, and the fact that we try to narrow it down or give you the basics, because we assume that you understand two things. One, that a 20-minute or 30-minute show can't possibly involve all of the aspects of a particular issue. And number two, that we're basically saying to you, once you listen to us, go sit down with a professional, whoever he or she may be, in order to expand on what we've told you. Now that you're aware of it because of our show, you can go sit down with somebody and really learn all of the specifics that apply to your situation.
Yeah.
Well,
that's excellent, Bill. Very complex topic that we're talking about here. I know you tried to make this as basic as possible, but folks, if you still have questions, please reach out to your estate attorney, reach out to Bill. Here's his contact information if you just want to bounce him a message or give him a call. And I'm sure Bill would be happy to help out in any way, shape, or form. So with that, thank you, Bill, for today's topic. Really appreciate it. I think today's,
no problem. Thank you.
Today's show went pretty much without a hitch. I accidentally touched the outro video. That's why you saw that.
Yeah, I saw that little glitch. So there you go. We're christening our first re-christen our new live show with a technical glitch. What else would you expect, right? It had to go. Yeah. Couldn't be perfect. Right. So anyway, we're only human, and
that's right.
And so I'll cast my appropriate aspersions on Rick once the show's in.
Yeah, there you go. I'm guilty. Guilty as charged. So, folks, I hope you enjoyed today's live stream. We're going to continue to do this. for every show that we do from here on out for the foreseeable future. Our scheduling will relatively be the same. We'll still do this bi-monthly. Check our Facebook page at Facebook or YouTube or any of our social media platforms, and you'll get an update as to the exact date. We haven't determined that yet, but it'll be in a couple weeks from now with a topic to be determined. So
yeah, and we have rolled around in discussions the possibility of changing the date and time that to allow people who want to watch it live to have more free time. And we've discussed certain things which we'll keep between ourselves now. But if you have any suggestions that you think might be worthwhile, please send it in to us and let us know. We'd be happy to listen to any suggestions you may have.
Yeah. And you can always drop those messages in on any of the social media platforms, or just send us an email at bottledbusinesssenseshow@gmail.com. So with that, stay tuned here on Facebook and YouTube. You'll be the first to be notified of the next subject matter that we'll be discussing on the show, and the exact date. It'll be at least 2 weeks from now, probably 2 weeks from now, but we'll take a look at the calendar and let you all know. So thanks for joining us today.
Take care, everybody.
Have a great day.
Have a great day and be prosperous. See you next time.
All right. See you guys.